Welcome back to our final panel session of Talking Justice 2017. We're going to ask what role can restorative justice have and can it align with Indigenous culture? And this whole conversation, I think, around justice and Indigenous culture is a really interesting one. And I keep on coming back, as I've been thinking about this, to the wonderful welcome to country that we had from Rodney Carter last night, where he spoke about being, an Indigenous man and then speaking to the family court about his culture and the importance of that being understood, that knowledge and that law and those connections being understood by the imported Anglo culture, Anglo legal culture and law that we have here. And I think that was a really wonderful illustration of the fact that we need to be awake and alive to what's all around us. Our speakers this afternoon, David Moore, lawyer Nick Espie and Auntie Lois will talk us through restorative justice programs that they have intimate knowledge of, and they're going to help us explore the potential benefits of restorative justice models within Indigenous communities. So how does restorative justice work in Indigenous communities? Can it improve community safety and lower incarceration rates? How can we distinguish success from failure? How do the principles of restorative justice align with traditional values and practices? Can restorative justice programs forge a link between traditional Indigenous values and our criminal justice system? Our first speaker is Nick Espie. He's an Arrernte man with family ties to Alice Springs. He also has family connections to the top end and, through his kids, further family connections in the Kimberley. Nick worked as a lawyer in the NT before moving 11 years ago to the Kimberley region. He spent 7 years with the Aboriginal Legal Service of WA and 4 years with Legal Aid Western Australia. Now, Nick is currently, and this comes back to what we were talking about this morning, he's currently working for the NT Royal Commission into Juvenile Detention and Child Protection as a community engagement officer, and he will return after working on that project. He will return to WA Legal Aid when that's done. Would you please welcome Nick Espie?
Good afternoon. I'd firstly would seek to acknowledge the traditional owners whose land we're meeting on here today, and thank you all for being here and for the invitation to speak. As mentioned, I'm a lawyer that's worked in the Northern Territory as well as the Kimberleys. Speaking about the issue of restorative justice, I guess firstly, I suppose I would acknowledge that restorative justice itself is somewhat of an Aboriginal concept and process. It is the process of which disputes have been settled by Aboriginal people in this land, and certainly from research it seems Indigenous peoples in other parts of the world also have similar processes. Having said that, it does seem people in the Northern Territory and elsewhere have looked towards places like Canada and New Zealand for inspiration in finding restorative justice type programs and solutions. However, I also would suggest that there are many local solutions, many local programs that are already working, already integrating traditional customs with the Australian legal system, both in the courts and outside of the courts. There are a number of law and justice committees running in the Northern Territory. These are groups consisting of a panel of community elders, representative of various family groups or clan groups within those communities. There's the Kurtji group in Lajamanu, who've been operating for many years and are perhaps one of the earliest examples of these types of committees. The Bunawara, who are a group in the community of Manangrida in Arnhem Land. There's also another group, the Ponki mediators, who operate in the Tiwi Islands. These groups have involvement in the court process. These days, that's usually in the form of meeting prior to an offender going to court, producing or after discussing the various offences that a person may have committed, discussing it with each other, they being fully informed of those offences and the circumstances, they produce character reference type letters, or letters that are delivered to magistrates and on occasions judges, discussing the offender, the circumstances, cultural matters or personal matters relevant to the offender and to, in cases, victims. This is an example of where these people often consist of the lawmen and lawwomen of those communities, senior law people within their own legal system, and having met a lot of these elders, I can say they're people that can speak with great passion about trying to find common ground where the Aboriginal systems and the non-Aboriginal legal systems can work together for the benefit of their people. Similarly, in Turkey Creek or Warman, which is a community in the Kimberleys, the East Kimberleys, for many years there's been a group of elders that would sit on the bench with the magistrates while court presides. They would offer advice, insight and comments to the magistrate. They would also, on occasions, address the offenders, who are often people they know, often, well, always a connection of some sorts to those people that appear before the court. That creating a system where that court process is more a system of being judged by your peers and by your elders in the community, and perhaps a way of making people more accountable. The Ponki mediators are also, as I said, a group in the Tiwi Islands. They often not only provide references for the benefit of the court, but also solutions, including culturally appropriate rehabilitation options, culturally appropriate peer support. That's often in the way of finding the appropriate person with the appropriate kinship or skin name relationship to that person, being the one to assist them, facilitate rehabilitation within the community. These are all things that are going on now, have been going on for a number of years, and having some degree of success. As I said, the Kurtji group is one group that has been around for some time. Just going back a number of years now, back to 2002. Firstly, whilst acknowledging there are many traditional ways of dealing with conflict and disputes and dealing with people who've broken Aboriginal law, many of those options include mediation, where families talk and discuss offences. There's occasions where people are banned from their community or sent out to various parts of their own country as options. Having said that, corporal punishment is also something that is part of Aboriginal tradition. It is a way that disputes have been settled. It's a way that has in fact been known to the court and been addressed in the courts in the Northern Territory, also in Western Australia and other parts of the country. And I say, going back to 2002, I make mention of a matter. There was an offender by the name of Kevin Webb who stabbed a number of people in Alice Springs, including killing one person. This matter sticks in my mind because I happened to be driving past the scene where the victim lay dying on a crossing within the township. Kevin Webb was a man that was given bail prior to his sentencing. He ultimately was sentenced for manslaughter. But back in 2002, he was granted bail to return to the community of Niripi. Magistrate who granted bail was aware that the purpose was to go and receive traditional punishment in the form of payback. Specifically, or ultimately, he was speared 13 times in his leg by members of his family and the victim's family. Certainly, this is people nowadays would consider quite harsh punishment. It's something that is at odds with the Australian legal system. This caused some discussion. In fact, 2 years later, there was a similar situation where a man named Jeremy Anthony applied for bail. Mr. Anthony had killed his wife. He was responsible for her death. He's someone that had, not taking into account obviously the seriousness of such an offence, he'd shown quite genuine remorse and shown a desire to be subject to payback in his community of Lajamanu. On this occasion, as I said, there had been some discussion prior to that and some debate within the legal circles about this. Magistrate on this occasion didn't grant bail with those conditions. The bail essentially was that he could go and reside at the community of Nooka rather than returning to Lajamanu, where he was likely to be subject to this payback. And the main reason being the legal system, within the legal system, whilst we can consent to assault, a person can't consent to injuries that would, under the legal definition of grievous bodily harm, occur to that person. Mr. Anthony was granted bail, told not to go to Lajamanu. However, he did travel to Lajamanu, and he also received payback. He received that traditional punishment, which included being speared in the leg by his deceased wife's family, and also being struck by members of his own family. Whilst these things are quite harsh or considered harsh, they're organised affairs. On this occasion, the judge that subsequently dealt with his sentencing took into account that he'd received this punishment. There was affidavits produced to the court by elders in the community who sat on the Law and Justice group. They discussed what had taken place in detail. It wasn't a situation of a lynch mob attacking the person and dishing out punishment. It was all organised affair. It was seen within that community as a restorative process, as almost a reconciliatory process, and that was a matter that occurred in 2004. Certainly there's not so much discussion on that sort of form of customary intervention. In 2007, the Northern Territory had the intervention, and it became... The Northern Territory National Emergency Response legislation was enacted. Section 91 of that legislation specifically prohibits courts taking into account customary law in matters involving either bail or sentencing of offenders. It is unfortunate that those types of matters are the only ones that we'll focus on in a negative way. As I said, elders and community groups have many ways of dealing with offenders. Notwithstanding 10 years of specific prohibition on taking that into account, these groups have prevailed. Innovative options do take place in communities. Whilst there are these options that include things that occur in court, there's also solutions that can happen and do happen outside of the actual court process. There are people with innovation and with the right attitude working either for Aboriginal communities or working with Aboriginal people. As I said, there are people quite passionate, Aboriginal people that are passionate about bridging that gap. One thing that's relevant to restorative justice, and restorative justice in the sense that it's a process where affected stakeholders play a part in solutions to offences. And looking at the bigger picture, there are programs running in various places. One thing I'd also mention is night patrol or warden schemes, which are part of many communities. Started way back, or many years ago, about 40 years ago. It was one of the first programs that was run by a bunch of elderly women that were concerned about children, concerned about families, and upon their own initiative set out to patrol their communities and deal with disputes, mediate disputes. This is something that's thrived nowadays on occasions. The community of Bendigo, which is in the Tanami Desert at the edge of the Kimberley region, is a community where when I first started working in the Kimberleys as a lawyer, there was an officer in charge of the police station there, a two-man police station. The sergeant who worked there was also an Aboriginal man from the Kimberleys. He's someone that showed the respect to the community. He's someone that consulted with the community, and that was reciprocated. The people within the community respected his judgment. He was well aware of the community-type meetings that occurred within the community. Often meetings are held in a public space involving people on either sides of some sort of dispute. He was someone that would allow these meetings to take place. Occasionally they were perhaps situations that got loud and heated when there was debate about various issues. However, he was someone willing to stand back and allow this process to take place. On top of that, he was someone that formed a warden scheme consisting of leaders within the community and essentially empowered local people to find solutions, to settle disputes, to reduce offending against each other, and also offending by way of burglaries or property damage within the community. Unfortunately, he ultimately left that community and went on to other things. And I guess it raises the issue that there can be these informal things that take place that have great success, don't necessarily involve reinventing the wheel, so to speak. Unfortunately, sometimes all it takes is one person to leave and someone else to replace that person. That community subsequently had a new officer in charge that didn't have the same respect to the community, showed somewhat of a zero tolerance to community meetings, which may have got a little bit loud. In fact, I can recall attending the community as we would do on the court circuits once a month and finding people charged with various offences relating to disorderly behaviour type offences, simply for being loud, yelling, or perhaps swearing. So that was a community that had struggled to be able to resolve their differences based on the traditional way of meeting and discussing problems. I recall, and I guess going back to the fact that there are still some strong connections to culture, to traditional customs. There was an old man whose name I won't mention, a matter that was dealt with before Magistrates Court, who was charged with striking a woman that was in, he called his wife, a younger woman that was in that, through this kinship system was considered his wife by their skin names. there was a dispute involving her. Traditional custom dictated that it was his role to punish this woman. This was an old man that was born in the bush, grew up a traditional life, had never seen a non-Indigenous person until he was a young man, as is the case with many people in the desert region. Speaking to this man and asking him what happened and what the story was, it was quite evident that it was a situation where he felt that striking this woman was the best option to reduce conflict within the community, to reduce the situation where other people would step in and would commit violence against her as a form of payback. He was also someone that believed in tradition, in spirituality, which may also be considered to some extent the superstitions of Indigenous people. And it was his belief that should he not deal with this matter, harm would come to this woman in a spiritual form. So those are some of the dilemmas and the tricky situations that are faced by police and faced by the courts. In any event, that community, as I said, there was a zero tolerant approach. Not that I'm condoning that sort of violence, but that's a community that's now spent a number of years dealing with feuding, which spills out into the streets of the community in the way of family feuds and often violence. Dealing with Aboriginal people, there are some programs that succeed, some that fail. Using that community again as an example, the legal aid service in Western Australia, in fact the office I've left for a short period of time, had as a community engagement officer that attended that community, an Aboriginal man that worked in that community, and discussed and facilitated the possibility of assisting in mediation. And I spoke to him just 2 days ago and to ask how that process was going, and he told me essentially that they'd stepped back whilst they'd offered their services to assist in the community. Simply having that conversation was enough that it kick-started people in that community to resolve the matters themselves, and they have since, as I understand, mediation's taken place and conflict has relieved itself. This is a community that has, in the last few years, because of various feuding and disputes, there has been somewhat the overhanging threat of community closures, and specifically the threat that if the community didn't resolve itself, they would be closed. Also, similarly, it was a community that was government had strong desires to also subject people in that community to welfare management, which is being trialled elsewhere in the Kimberleys and also South Australia. There are other initiatives that I would touch on that again are not necessarily court-based initiatives. Another community in the Kimberleys of Ulumbarra was also a community where there was a lot of conflict, a lot of feuding, which was often in the form of hundreds of people throwing rocks, sticks, burning each other's property. There was a change in staff at the police station, and there was a sergeant that subsequently ran the police station. He believed in community policing. He consulted and got to know the community quite well, and ultimately was right on top of any conflict that arose, to the point where he would invite anyone that had any sort of disputes to the police station, not in a situation to charge them. He would sit down with them, talk about their problems, and at the end of the day, he'd take a photo of two young men, for example, with their arms around each other or shaking hands. He'd give them a copy of that, and it would be left at that, as opposed to their individual disputes spilling out into the community. He's also someone that another simple idea he had was when people would come into his police station yelling, shouting and swearing, rather than, as was the case with previous police officers there, charging them for matters involving abusing them or disorderly type matters. He had a barrel of lollipops and would give a chup-a-chup. And he says the most angry and aggressive people would soon be quiet and have a lollipop in their mouth. He's someone, again, that gained the respect of the community, assisted people in mediating, in having common ground and being able to resolve their differences without violence. Another situation, another community in Northern Territory, the community of Worawa, which was over the years known for similar type violence in the form of two large gangs that often opposed each other and caused chaos in the community. There was the coming together of these two groups, initiated by one of the officers that worked in the community. He recognised these two gangs were really extensions or modern versions of the traditional clans and systems. It got to a point in that community where, again, he empowered these gang leaders who shook hands and then began running a night patrol program, which brought peace to the community. And this is a community that a few years prior had riots that had involved an officer actually shooting and killing a member of the community. Peace had been brought by this simple act of speaking to the community, asking the questions and understanding the dynamics. Having returned to that community after the school holiday period, had a positive conversation with the principal of the school, who advised that it was the first time in years that the school hadn't been broken into. So not only had the community had peace and conflict had been resolved, but other offences, property damage and the like, had reduced, because it was a case where the younger people in the community who would commit those sort of burglary or property damage offences respected the people that were patrolling the streets, so to speak. So those, as I said, are things that occur outside of the court, as well as some of the programs such as the law and justice groups that occur within the court system. And I suppose, how do we forge those links? It's reciprocating the respect of the systems. Perhaps not to finish on a sad note, but I mentioned the elders in the Warman community who sat for many years, probably more than 10 years, with various magistrates. Unfortunately, as I said, it often takes either the right or wrong attitude to make something a success or a failure. Quite sadly, I was approached by the elders at the first sitting of a court in Warman with a new magistrate a number of years ago, who they wished to meet with prior to the commencement of court. They were there quite early, waiting to speak to her, introduce themselves, offer their service again. And quite unfortunately, the middle of the morning when the court had then commenced and she hadn't sought to talk with them and meet with them, they sadly left. And that's a program that has now ceased. And it's, I suppose, perhaps a sad example of those people being passionate about what they would do, being able to provide that for their community at no cost. It was something they volunteered their time, and unfortunately that fell over. I'm not sure how I'm going for time.
I think we need to...
About time to wrap it up.
We'll plenty of time during the panel.
Yeah. Perhaps I'll leave it at that, and maybe other questions.
Yeah, great. Nick, thank you. And so many issues, and we'll looking forward to your questions for Nick shortly. And our next speaker is Auntie Lois Peeler. Now, Lois is a recognised elder of the Yorta and Wurundjeri people. She's a passionate educator and leader, and she's the Executive Director and Principal of Worawa Aboriginal College, which is the only boarding school catering specifically for young Aboriginal women. She's also one of the original members of the Sapphires, the all-girl singing group from the 1960s, whose story was recently made into a very successful film. And she's also acknowledged as Australia's first Indigenous model and TV presenter. She was also named Senior Victorian Australian of the Year back in 2017 and was a finalist in this year's Australian of the Year Awards. Would you please make Auntie Lois welcome? Thanks.
Thank you. Well, good afternoon, everyone. Can I begin by acknowledging the Dja people as the traditional owners of this country, and I pay my respects to elders past and present. Let me say I'm delighted to be a participant in this Talking Justice forum, and I really thank the organisers for the invitation. To me, it's particularly meaningful as we prepare to commemorate the 50th anniversary of the 1967 referendum and the 25th anniversary of the historic Mabo decision, Sorry Day, and also coming up is National Reconciliation Week. Having accepted the invitation to speak at this forum as part of Law Week, I reflected on the historical circumstances of Australia's First Nations people. Dispossession, dislocation, cultural fragmentation and marginalisation has led to poverty and disempowerment that comes from being displaced from our lands. Our internal law and our traditions, and has led to current crisis in which many Aboriginal people find ourselves. High unemployment, poor health, high mortality rates, low educational attainment, and high incarceration rates. These have become endemic in Aboriginal lives. So on any social indicator of well-being, health, education, housing, employment, civic participation, the numbers in custody, you name it, Aboriginal people are always overrepresented at the wrong end of the scale. My upbringing included family life on Cummeragunja Aboriginal Reserve on the traditional lands of my mother, the Yorta peoples. The Yorta have a long and remarkable history of political activism. And on my paternal side, my grandfather was a Yarra man who as a child lived in the children's dormitory on Correndurk Aboriginal Reserve. This too has a remarkable history of political activism. William Barrack led Correndurk residents in a campaign of delegations, strikes and protests and letters to the press, expressing their concerns to the Victorian government and the public about changes to Correndurk Aboriginal Reserve. And then in 1938, on the 26th of January, the Aborigines Progress Association, led by William Cooper, Jack Patton, William Ferguson and Doug Nichols, held a day of mourning to highlight the appalling conditions of Aborigines. The organisers used a statement which, amongst other things, stated, "We do not wish to be left behind in Australia's march to progress. We ask for full citizenship rights, including old age pensions, maternity bonus, relief work when unemployed, and the right to a full Australian education for our children. We do not wish to be herded like cattle and treated as a special class. And as regards the Aborigines Protection Board of New South Wales, and white people in the cities do not realise the terrible conditions of slavery under which our people lived in the outback districts. This was in 1938. So I grew up surrounded by strong men and women who led the fight for civil rights and social justice for Aboriginal people. There was a strong belief that education was the key, and I still have that belief. Education of not only Black Australians, but also educating the broader Australian public of the conditions under which Aboriginal people were forced to live at the time. So I chose to focus on education as a means of improving the situation of our people, providing opportunities for our youth. As you've heard, I currently hold the position of Principal at Worawa Aboriginal College. I'm also Chair of the Regional Aboriginal Justice Advisory Committee of the Department of Justice and Regulations. It's in the Eastern region. And that's where Worawa Aboriginal College is situated, in the east. So Worawa is a boarding school that has been delivering education to Aboriginal youth for over 30 years. And during that time, it has built a comprehensive understanding of the needs of its students, and many of whom have not succeeded in the mainstream. And they come from some of the most disadvantaged communities in Australia. My work and the work of my sister Hillis Maris, the founder of Worawa Aboriginal College, was to create transformative experiences to prepare Aboriginal youth for life and work so they may shape their own world. We already held within us the world's oldest living culture, with all its meaning and all its complexities. We understood our own significance, but we're not allowed to express it. So Hillis knew what we needed for our school, so our culture could be held as precious and central to all learning. The school system at the time shunned our people, ignored our culture, our history, and our being. Instead of making it the bedrock of any additional cultural understandings, it made it something peripheral at best, but shameful at worst. This was the impetus for my family's passion for our own place, meeting our needs, our own curriculum, and our ways of knowing, doing, and being. As an Aboriginal woman, having had personal experience of living in harsh conditions, I have first-hand experience of the disadvantage faced by many of the young women that present at my school. My personal experience provides a sound basis to address issues that our girls present with. So it's a boarding school, but the families of the students at Worawa Aboriginal College are means tested against AB study requirements for eligibility under home conditions. So as a result of such testing, many of the young people who meet that criteria may be from families or communities experiencing one or more of those common identified stress factors. And sometimes characterised by family breakdown and a whole range of social dysfunctions. So recognising and redressing the effects of those factors with strong well-being and residential support is central to the Worawa model and a critical enabler of engagement and educational success. Indeed, Worawa is in a unique position to address these challenges. With a relatively small student cohort, a low student-teacher ratio, and a commitment to personalised learning plans in a boarding school environment where high levels of supervision and encouragement are able to be provided. Worawa can provide new opportunities for educational success and build in our students the confidence, skills and understandings to shape learning pathways for themselves beyond secondary school. At Worawa, we believe in the ripple effect, that the young women who come to Worawa from communities all over the country will return to those communities with their new skills and act as agents of change. The college values are relationship, responsibility, respect, and rigour. So we place emphasis on a strengths-based approach, building a culture of well-being, changing the culture of violence, building resilience, positive relationships, shared beliefs and values, that resilience and optimism. And restorative justice is embedded in this college's practice. For us, restorative justice reflects the traditional way of our elders in yarning about things to find a solution. And sometimes that might take a long time. We have a saying, if you speak, you own it. So we want the girls to own their behaviour. At Worawa, we encourage students to take responsibility for their behaviour, to take ownership of their actions, to be respectful and practice deep listening to the other person, reflecting on the issue at hand and coming to a resolution, and then it's finished business. Once the restorative justice session is completed, the matter is finished. This process works well in our school. My role as chairperson of the Eastern Regional Aboriginal Justice Advisory Committee involves initiatives aimed at preventative and diversionary measures for Indigenous youth from involvement with the justice system, and issues arising from the Royal Commission into Aboriginal Deaths in Custody, which was released in 1991. We're still dealing with many of those things. But the preventative and the diversionary things are the things that I'm personally very engaged in. As we know, the Royal Commission highlighted both the overrepresentation of Aboriginal people in the youth and adult justice systems and the accelerated rate of progress through the justice system by many young Aboriginal people. The findings included the need to devise strategies designed to reduce the rate at which young Aboriginal people are involved in the welfare and criminal justice systems. So we're all aware that poverty, low educational attainment, unemployment, history of family breakdown and higher representation of rural and remote youth feature consistently in the youth justice profile. My work includes advocating for an enhanced approach to well-being for our children. I'm wanting to see more forensic mental health care and an approach that is therapeutic rather than punitive. I'm looking to share the positive experience of restorative justice at Worawa Aboriginal College in working with our youth in the justice system. Thank you.
Thank you, Lois. Our next speaker, David Moore, supports individuals and organisations to change adaptively and communicate constructively. He works as a facilitator, an academic, a writer and a system designer. David is the current president of the Victorian Association for Restorative Justice, and he's recently been a consultant to the Defence Abuse Response Task Force and is currently a principal consultant to the National Redress Scheme. Would you please welcome David Moore?
Thanks, Damien, and thanks, Auntie Lois and Nick. Good afternoon, everyone, and I also begin by paying my respects to the traditional owners of the land we're meeting on this afternoon. Look, I'll speak briefly, and then I think it's probably best if we get to the panel discussions. So I thought what might be a useful way to frame what we've just heard from both of the previous speakers is what Nick was talking about, work in the Territory and Western Australia, involving improvements to frontline policing, adjustments to the court, and the way in which communities attempted to resolve disputes and conflict, including those vexed and high-profile issues where traditional systems of symbolic reparation through payback were there were some attempts to combine that with the colonial court system, and then legal changes made subsequently. So these are difficult issues, and there's a lot of experimentation going on. And as Nick rightly said, a lot of the experimentation includes comparing what's happening in Australia with what's happening in Aotearoa, New Zealand, and what's happening in Canada. And I think, as Auntie Lois pointed out, obviously what those countries have in common is a history of dispossession, colonial systems imposed on Indigenous systems, but also now an opportunity to look at what's worked in terms of the impact of the sort of dignified activism that Lois was talking about, and also programs that we have actually seen to be successful across those countries, and a couple of other places we don't typically think of as comparable, such as northern Scandinavia, where the Sami people actually look to a lot of what is happening in Indigenous justice in our part of the world. So very briefly, I got involved in this field about 25 years ago, actually around the time of the Royal Commission into Aboriginal Deaths in Custody, because I was in charge of the Justice Studies program at Charles Sturt University, and I just happened to be in the right place at the right time when a proposal was put forward to build on what our friends in New Zealand had come up with by way of the now famous 1989 legislation, the Children, Young Person and Their Families Act, which essentially introduced a group decision-making process in child protection and youth justice into the New Zealand national system, essentially because two pilot programs run by Maori activists had been so successful that quite sensibly the national government said, well, if it's that successful, why don't we offer it to everybody? Now, New Zealand being different, with 20% of the population being Maori and Pacific Islander, that was a radical but sensible reform, which then other countries have been able to take the lead from. Where we were in southern New South Wales, a group of us took the suggestion, said we don't have to legislate, we can run these group processes in the legal space where police currently provide cautioning, much as Nick was describing happening with some thoughtful police sergeants in the Territory. And in retrospect, what we got very much right at the time was focusing not just on the overarching principles of restoration, or even the program, this happened to be run in a police program, but more importantly on the actual process, what goes on in the room. And I think that's a useful way of thinking about what's happened over the last 25 years, because in effect we've had two parallel reform movements if you like. One being the Indigenous-focused courts, so adjustments to the court system to try, if you like, to begin in some small way to make up for the history that Auntie Lois was summarising. And in parallel, we've had the development of this group conferencing process, which we were originally just using as part of our diversion program for young people, and which, as it's been applied and modified more and more broadly, is coming to be understood for what it really is, and that is a mechanism for introducing deliberative democracy into decision-making. So the group conferencing process, which we originally used in Australia just for youth justice and just for diversion in programs that were legislated starting in the mid-1990s, South Australia, then New South Wales and the like, and eventually the whole of the country, with Victoria being one of the last places to legislate in 2005. That process is now being far more widely used. But in parallel, and many people in this room will know this, the system of Koori courts, Murray courts, Noongar courts has developed starting in South Australia, and in fact originally strongly supported by a magistrate who'd worked in PNG in the late 60s and early 70s and had seen what could and shouldn't be done with a colonial system imposed on Indigenous justice systems. So there was a rapid expansion in parallel but largely separately of group conferencing programs, initially just used in youth justice and initially mainly for diversion through the 1990s and early 2000s. And then from the late 1990s and through the early 2000s and continuing up to the present, we've had these systems of Noongar, Murray, Koori courts. So again, in the Victorian context, many people here in this room, in fact some of you may have been involved directly with these, will know about the Broadmeadows and the Shepparton and the Latrobe Valley and more recently the Mildura Koori Court. And the focus in those programs has been on, in a sense, introducing a degree of respect, directly involving community elders, slightly changing the layout of the court, changing the look of the court, the physical space of the court. And all those things are useful and important and helpful. What I think is really interesting now is in parallel, these programs involving group conferencing, which are expanding well beyond youth justice, were appreciated in an Indigenous setting, ironically, not so much in New Zealand and Australia, but overseas. So a group of us were asked in the late 1990s to go to Canada, and we literally worked from BC right across to Newfoundland and Labrador, working specifically with members of the Aboriginal Justice Learning Network, training people in group conferencing. Because their argument was, well, this is culturally appropriate. We've been sitting in circles for a very long time, as in roughly 15,000 years, sorting out issues in a sweat lodge. This allows us to introduce this into the mainstream justice system and get away with it, where we're actually involved directly in decision making. Now that group conferencing process, of course, it was criticised in Australia as being not appropriate for this group or that group. The very first one we had in Wagga Wagga was, this won't work for Wiradjuri people. So I said, well, you go and tell that to the Land Council, they like it. So this was people coming down from Sydney wanting to shut something down because it was democratic. But what we've since done is work out that these group conferencing processes are not primarily about victims meeting offenders. It's about a group of people in conflict being given the opportunity, exactly as Nick was describing, to be brought together with their extended networks of relatives and with professionals who might help them, and work through issues to the point where we can leave the room with an agreement that's actually realistic, sustainable, takes into account everybody's conditions, and is something we couldn't have crafted on our own, and certainly wouldn't accept if it were imposed on us by a magistrate or a protection worker or whoever else. So that process in recent years has been, it's been recommended, as again many people in this room would know, by the Victorian Royal Commission into Family Violence, ironically because it was trialled successfully and extensively in Canada, where they used our training manual in programs run originally in the 1990s. It's been available to adult courts in Victoria under the 2010 adjustments to the Sentencing Act. It's just that no magistrates have been using it because the only programs that have been funded in Victoria to use this group conferencing program are indeed the children's court programs. So it's perfectly legal, it's just there are no programs, or there have been no programs. However, the problem-solving courts, so these are not only the Koori courts, but also the drug courts and also courts with a dedicated family violence list, are now saying, well, why is it we only have this supported judicial decision-making for the children's court when it's been tested with randomised controlled trials and consistently found to reduce reoffending, give us participant satisfaction rates that we don't see anywhere else in the system, and also it turns out to particularly reduce reoffending in serious cases, particularly cases involving violence. Why are we not using this? What's heartening is that a lot of magistrates are aware of this, and there's now an open discussion not about should we do it, but how do we do it. So essentially we're moving to more democratic engagement, which is, I think, what was partly hoped for with the initiatives to create Koori courts, but what for a long time was not adequately understood was how much skill involved and how many techniques needed to be brought to bear by a convener to make this happen. And that's really what Auntie Lois is talking about in the magnificent work they've done at Worawa, which is to say we have principles of, and I won't repeat them, you said them much better than I did, but that series of principles starting with R, including respect, and their high expectations, but where the students are actually taught a skill set around relationship management, so that when they, after their years at the school, when they go back to their communities, they take with them not only the curriculum content, but a tangible set of powerful skills in relationship management that actually help us resolve disputes in our community, get decisions made at a collective level, and so make it easier for us to live and work and study together. And so we're going beyond just the aspiration to the understanding that there's a learnable, teachable skill set. And it's in terms of justice system, formal justice system applications, we're moving beyond that simply being a mechanism for diverting people from the court to something we're actually using in courts, and also that's a process that's being made available post-sentence, so that it's all very well to give people a sentence, but we haven't in any way restored right relations among all the people who've been affected by a crime. And until that's done, problems fester or get worse. And again, the examples Nick was giving from the Territory in the West show how you can do that well and how you can do it not so well. And ideally, we're trying to move to a situation where these approaches are understood as a system, so that when a good person and good committed professionals move on, the system doesn't collapse. That we have this general approach embedded in how we work. And so, just as a wrap-up, and I think this is consistent with the sort of work you see at a school like Worawa, the idea is when harm is done, firstly, we don't want to do any further harm, so do no further harm. And then, rather than doing things to or for people, provide a process so people can work with each other to try and sort things out. And the third and final fundamental principle is let us try to restore right relations. So as far as possible, resolve the disputes that are amongst us, and as far as possible, work out what's still causing conflict. And as far as possible, address and transform that conflict into cooperation, which is where I think the common theme running through all the effective programs we've just heard described is that there's a principle of restoring right relations, and increasingly we're aware of how to actually do it and how we can systematise that. Thank you.
Lois, I'm really interested to know the kinds of disputes where you use these restorative justice framework. Can you tell us about some of the ways that it has been used at Worawa?
Where we use it?
The kinds of disputes, the kind of day-to-day disputes, because I think that's really interesting.
Well, just to give it some context, as I've indicated, girls come from communities across the country, bring different experiences with them, they're from different language groups, they're teenage girls, so sometimes little conflicts arise. And when we see that happening, we bring the girls together, and it's usually in a supportive setting, and we give them the opportunity to talk about what it is why they're aggrieved, and listen to the other one's story, and they both get to talk. Now, for some young people, not only our Aboriginal people, I think for any young people it's quite difficult sometimes to actually go through that process, to sit down and listen to someone and to talk about why they're feeling hurt or sorry, what made them angry. So it is very much a learning process for them. And what we found is that it works very well, that once they've been able to put on the table what it is that's concerning them, and they listen to the other person, and at the end of the day, after they've finished the session, they either shake hands or give each other a hug, and then it's finished. What is interesting about this is that we have heard that girls have taken it back to their family, and they have taught their siblings or others in the community about how to do this with great success. Small steps at the moment, but at least it's being talked about as a process to resolve some of the issues. Now that's a big step, because for many, there's built up anger, there's these sorts of things that are quite common for teenagers, but their reaction might be something that's quite violent in nature, like picking up a stick or something like that. So to be able to sit down and to talk it through is a huge step, and that's how it works at Worawa.
Very interesting. I had the very good fortune to visit the Tiwi Islands a few years ago, and I saw the Ponki mediation in practice, and you could feel the vibe in the kind of the school grounds kind of change as something's kind of tension built up, and then very immediately there was kind of an intervention, and it was very kind of immediate to see things dissipate. It was quite extraordinary. And just, I don't know if this is also the way your system works, they also kind of address kind of long-running, very long-running issues. So a prisoner was leaving jail and he was being reintegrated into the community, and he went to talk to the family of the victim of his crime, and it was extraordinary to see those sorts of principles, I think, similar to what you're talking about, being used to talk it through, and so you could have, I think you used the term finished business. It was very humbling to watch both of those processes. Yeah. Do we have any questions from the audience? Yeah?
At Worawa? Right. Well, we had Dr. David Moore come and work with us to start the process. So
it's an inside job, though.
And it's been some 6 years since we started using the Restorative Justice process, and we've possibly Aboriginalised it a little bit, to suit our particular organisation and the way in which we do it. But the process itself remains the same, giving people the opportunity to talk. So it's I guess a standard type of process. Yeah,
so I just concur with what Lois has said, that the school rightly has worked out how to do this for the particular circumstances of Worawa, but generally how to improve relationship management in schools is something that a lot of the conclusions you reach seem obvious once you reach them, and they can take years to get there. So, our first trial of the group conferencing process in schools was in Queensland in the 1990s, and that was there's always a political impetus to these things. So there it was, while we've got outrageous rates of suspension and exclusion in response to bullying, let's have an intervention. And so we trained up some school guidance counsellors, and sure enough, rates of suspension and exclusion dropped. So on a larger scale, we tried that in New South Wales, and we did the urban, regional and remote area, so including Bourke, Worawa and Walgett and so on. And the interesting thing there was we also got a significant reduction in suspension and exclusion. So we went back and talked to the school staff, and in many cases they said, we haven't used that group process. We had this wonderful process and you didn't use it. We've still got the results. And it was basically an early lesson in what Worawa's done, with a lot of sophistication, which is, there are techniques. There's the general principle of, if people have had a falling out, let's actually get a shared understanding first before we try and impose a solution. In fact, let's not even impose a solution. Let's give people a process to work it out. So that's the basic principle. And then there are some techniques. And in fact, then on a larger scale project over 5 or 6 years here in Victoria, working with a group of schools each year, we came to the conclusion that although this approach was called restorative practices generally, in fact it was relationship management. And again, I think Worawa was a standout example of doing this particularly well, saying, you train the staff and then the staff work with the students so that every issue that's inevitable with teenagers becomes a learning opportunity, a profound learning opportunity. So there is a structured method, some very basic principles, and then some techniques that you spend your life practicing.
Listening and understanding, I'm quite new to the concept of restorative practice, so it's fantastic to hear today. What's jarring in my mind is it sounds as though this is a wonderful approach that gets results from what you've said, and is widely acknowledged as being effective in the Indigenous community. I just wanted to get your comments on when I listen to what's going on in the political space about welfare reform and the measures that are very top-down. It's the elephant in the room. It's obvious that, to me anyway, that that's coming from one angle, and restorative practices coming from the other angle. So, I'm just interested to get your comments on that.
Nick,
actually, that's an interesting question and something I had actually meant to comment on. I mentioned one of the law and justice groups. Actually, a number of them are involved in the criminal side of court processes, but certainly they have ambitions, and in fact, without specifying and sort of directing to the specific group, there have been some successes where those same law and justice groups have provided assistance and insight to the court process for care and protection matters, and there has been some success in that, where there's seemed to have been a situation that could have been resolved without removing a child from family, having that input from the community. It's not only resolved the problem with that child and that family, but has become a situation where the child was returned to that family, which sadly is often not the case. So I guess it is something that hopefully, as those sort of groups are receiving more recognition and respect for what they're doing, it can move into other areas such as child protection. And I guess that's probably best if they start in that area, because I think it was said earlier today, discussions about the path of care to crime or being into care and ending up in detention, which is, as I listened to that this morning, was pretty much mirrored all the issues that are occurring in the Northern Territory, which I've been looking into in my current role with the Royal Commission. So it is where we need to start, in families, and I guess part of that problem, some do see, is there's more focus on child removal than assisting families, early intervention and family support. But there's also seems to be not enough attention in relation to child protection involving Indigenous families and children. I think there's perhaps a situation where the child protection services struggle to have an understanding of Indigenous values and things that matter to Indigenous families and children, and having a restorative process or an inclusive process where people in the community are more involved in dealing with the departments, child protection departments, and also the court process, gaining more insight into what is important to an Indigenous child. And there's some very sad examples that I've come across over the years of that focus on removing a child from this perceived concern, and often those children have a terrible life in care, and then turn 18 and go straight back to their families and struggle to reintegrate into the Aboriginal community, reintegrate into their families. So in the bigger picture, restorative justice, I think, it should be that focus, as you said.
I'd just like to make a comment as well in terms of what's happening in the area that I work here in Victoria. There's quite a bit going on from the Aboriginal community perspective. For example, you may be aware that there is some talk about a treaty, there is talk about self-determination, and we're looking at that self-determination from a justice perspective, and a lot of the things that Nick's mentioning about how do we look after our children, how do we prevent them from entering the system, child protection, justice. So small steps, I think, starting from the beginning, but I think giving the Aboriginal community a voice, and hopefully we can put some of those things in place that we see as really important, and it's all around our future generations, our youth, the way that we're doing things now, maybe turning around the system altogether. It's quite an interesting thing that's taking place at the moment.
Yeah, and look, I'll just add, because you mentioned specifically child protection, as, again, many people in the room would know that the substantiation rate in child protection for Aboriginal people in Australia is 6 times the national average. So that there's a big gap that needs closing there. The Victorian initiative from the departmental point of view is, since I think 2012-13, the department's been specifically supporting what they call family-led decision-making, and there's a specific parallel program of Aboriginal family-led decision-making building on a successful pilot in Shepparton, where the attempt is to engage, again, a larger social network and the right mix of professionals in the decision-making. And again, to the credit of the department, that they're increasingly aware that it's not enough just to have the principles, you've got to have the skill set for the people setting up and running those meetings if we're going to come up with the best available placement option, rather than simply going for foster care or whatever. So it's something that a lot of attention's being paid to, and I mean, again, I'm not here to support the department or whatever, but I have observed that they're very aware of the need to have processes that ultimately get everybody in the room, if it's possible, or at least connected up by video link or whatever, to make better decisions than we have been making historically in those really fraught situations, where you've got to find the safest residential option for kids under the age of 18.
The question reads, we've made some progress in closing the gap, but we've got a long way to go. What do the panel members believe should be priorities for governments prior to the next election?
You get to write the election platform there, Lois.
Where do you begin? Look, I guess, and perhaps it's also touching again on some of the discussion about sentencing children and adults that was mentioned in that talk this morning. And I guess there is that link between that and what we're talking about now with restorative justice. I guess a priority in an ideal world would be, and it was mentioned this morning again, the idea of tough on crime, which seems to be something that tends to get votes. It's something that feeds off of hate and fear, and in many cases feeds off of the racism in society, and that is a problem when it goes contrary to what all the experts and the evidence-based research suggests about how best to deal with issues of reducing crime and maintaining well-functioning and well-educated people in society. And I suppose my particular focus is on from the Indigenous point of view, a big challenge in my current role is looking at how do we, with the using a Royal Commission, how do you sell this idea that reducing crime, reducing children ending up in care and ending up in detention, how do you sell the idea that it actually is a better investment in money, if you want to put it in those terms, for the people that aren't quite as sensitive or passionate, convincing people that it's a better use of money, focusing on therapeutic rather than punitive measures, as Lois said, and focusing on local solutions such as restorative justice programs. Hopefully that's something that we can do. I think from the question was from a political sense leading up to the election. Well, I guess that's the difficulty is it seems all over the country that the tough stance on crime seems to be what sells. So that is a problem. I think one big solution, and it's great to hear about places like Worawa, is education, particularly looking at a lot of communities, Aboriginal communities in the Northern Territory, for example, seem to be no longer having high school. So year 6 is it. If you can't make it in boarding school, then, and you're from a community, that's you're 12 years old, 13 years old, and that's the end of your education. That's a huge problem. And finding culturally competent schools and programs, I think, is a big solution there, because I quite frequently come across children that end up in the justice system that may have gone to a boarding school somewhere in the country, and it is what a lot of young Indigenous people do in communities throughout the Territory and the Kimberley. They might go for a short period of time and they don't make it, and they return to their community, and that's the end of it. And quite often the only local solutions, as I said, if you're from a community, quite often it's a case that there is no year 7 to 12 anymore. So maybe the answer is value on cultural competence of programs.
And those schools have closed down, or those schools were never there in the first place?
I've certainly been finding that a lot of the schools haven't closed down. The schools generally have primary and high school all in one, but they no longer service those higher grades, which seems to be quite a concern.
Well, we get girls from communities where there is no option but to leave the community if you want a secondary education. And quite often families want to send them away where there are new opportunities, where it's so there is this huge gap in some of the communities where there is nothing. So we actually start working with the schools from year 5 and 6 to prepare them to come to a boarding school, and so that might eliminate some of the issues. Coming from a remote community, you can understand coming into a very structured school environment can be very difficult for the young people. But I want to go back to the question, if I may. I actually think that closing the gap is going to take concerted effort right across the board. I don't think that there's any one particular thing, to be honest. And I go back to what I said about what happened at the 1938, the Aborigines Progress Association, and how they listed things. They wanted equal rights. They wanted education for our children. And our children back then did not have access to education. So we're playing catch up.
Yeah.
So, there's a lot of things. Our health, we've got the worst health statistics in the country. So I don't think that you can take one. I think everything needs to be addressed at the same time. We just need more of a concerted effort, more money, because it is a matter of providing the resources to be able to address these things. And so, we do what we can in the areas that we work in, and I personally think that education is really, really important, because it's the future generations that's going to bring about change.
And if I can just add to that, I used to work many years ago in a Premier's department, and since then I've noticed that the gaps become even greater between the politics and media cycle, and I don't include Radio National in that, but where there's a pressure to provide simple solutions to complex problems, simple solutions that don't work, while the rest of us are grappling with ever more complex problems. Ultimately, to the extent there are solutions, that they involve setting up demonstration projects that don't work and then giving them publicity. And again, this is not a quick plug for Radio National, but one of the few outlets where you'll consistently hear stories well told is in programs like the Law Report and Background Briefing and the like, that actually go and report on success stories as well as abject failures. And you can see that one of the consistent themes in all of those is accepting that all the really big problems we're grappling with are complex. They're not amenable to simple solutions arrived in the high school debate that's in Commonwealth politics. And so, what's worth focusing on for all us like-minded activists is work out what works from wherever and commit to that, and eventually the stories get told as they should be about the sort of work that we're hearing about today.
Family violence or violence against women and kids is a problem that affects all people and children and communities. But it seems to me that in the Auntie community there is a unique tension between the aspiration that I think is broadly held to keep men out of the criminal justice system as much as possible, but also the great aspiration to keep women and kids safe. I'm just wondering if you could give us any insights on that tension, but also maybe the application of some of these principles in that environment.
It's an interesting question, and perhaps I'd raise one thing, which is, as you pointed out, violence against women and children. I guess one problem or dilemma is the national narrative of domestic violence. I think, from my experience working for many years as a criminal lawyer in Aboriginal communities, and life experience and family and associates that I've been through the same sort of problems. I think the national narrative is different. The non-Indigenous narrative is somewhat different to some of the different types of domestic violence situations that families find themselves in. Particularly, I can speak of the Kimberleys where I've been working for many years. Whilst violence between men and women is quite different, there's a growing population of female offenders of violence. And as I said, there's certainly different types of relationships, but I think we need to look that it's not a one-size-fits-all scenario when it comes to how to deal with domestic violence. I think, again, it's a situation where there's not enough people listening to what the Indigenous community has as solutions. Aboriginal people tend to, I think, look at options of trying to keep families together rather than immediately separating when there's issues of violence. They like to be more inclusive. When you're dealing with people that live in small communities, it's also a case that you have a lot more interaction with each other. Someone that's been a victim of domestic violence or any sort of offence, whether they continue in a relationship or not, If they're in a small community, it's a case where they will see each other on a regular basis. It's a case that, regardless of issues of violence, partners may separate and end up in a new relationship, but they'll still see their partner. Parents will attend ceremonies for their children in company with an ex-partner and a new partner. So there's that inclusive nature of community living with Aboriginal people. But as I said, it's certainly the case that there are many situations, and it's a delicate matter to address, but as I said, there are many situations where there are not only male offenders, but female offenders of domestic violence. And it's a situation where I think courts do struggle with that sort of accepted approach to what domestic violence is, as opposed to individual cases that may be quite different. And I can think of a number of examples where when making submissions in sentencing, often male offenders, and going through the list of all the injuries that I can think of one particular gentleman who lifted his shirt and showed me all the scars from where he'd been stabbed or struck by his wife. And those matters, for various reasons, had either gone unreported, simply by him not reporting them, or police attending and not seeing the female in the dispute being injured, and therefore not nobody being charged. There's also in the Kimberleys, and I'd say the Northern Territory is very similar. Services for men are not the same. We have women's shelters. Unfortunately, most places don't have the same services for men. So from a sort of frontline perspective, it's often the case if there's a domestic violence situation that police attend. And we have in WA temporary restraining orders, 24-hour or 72-hour orders, and when police attend a situation, it's usually easier for a woman to be taken to a woman's shelter and the man sent somewhere else. So it's often the case that those temporary orders will be put against the male in the dispute, regardless of what's happened. So certainly there's no way of excusing any domestic violence, but I think most situations, or a lot of the situations in the Aboriginal community are different, and there's a lot of different dynamics to it.
Can I just come in here to Nick? I think I take the long-term view that it's about education again. It's about breaking the cycle, because a lot of the young people, that's all they know maybe, because they've seen it. It's become normalised in their life. And so I think, showing them giving them the tools to deal with anger, such as the restorative justice practice, that's another way of them addressing the issues. But, right across the whole community, the white community as well as the black community, we're seeing an increase in family violence, domestic violence, because of the other issues of substance abuse, and these are the things that are fueling a lot of this. But I think that from my perspective, it is about you don't know what you don't know. So giving them some tools to use to eliminate some of the practices is, okay, it may be a long-term view, but I think that it's got to start somewhere. And, my hope is that the young women, and it's also about teaching the young women about respectful relationships, about, what is acceptable behaviour. And we have a number of programs in my school that address those things. I've got a program called Pathways to Womanhood, and that teaches the young women they can socialise with young people that and they can enjoy each other's company in a respectful way. And so I think it is very much for the young women that are going to be going out and being the mothers and the leaders in the future for me. But I think, I take on board that there are existing issues, in many communities, but it's not just our community either. I need to remind you that it's happening everywhere in the broader community as well.
And if I can just add to that, Peter, what you said, spot on. There's this tension between recognising that sexual violence and family violence should not have remained private issues, and what the activists sought for over decades was for them to be publicly recognised. And what got schlepped in with that was the criminalisation of individuals. So, starting with the Minneapolis domestic violence experiment, and then we got from the US the 1994 Violence Against Women Act. So all family violence was defined as violence by one individual male against another person. But fortunately what we've also got is programs that are working here. So for instance in Victoria, in Barwon Peninsula and Ballarat, unfortunately Bendigo's missed out on the first round, but there's an adolescence violence intervention program that's just been evaluated by the Institute of Criminology, very successful. The idea is borrowed from the States, from the Step Up program in Seattle, where each case is addressed on its own merits, and there's the option not only of individual counselling and the like, but family systems interventions. And the Royal Commission again has recommended that ultimately that sort of effective approach not be confined to solely cases involving adolescents committing violence in the home, but extended more broadly. So again, those programs can be run within the shadow of the law in a court setting or separate from. But I think we've realised that an approach that was taken for the last 20 or 30 years has not been as effective as people would like, and the tension is particularly clear in some Indigenous communities.
This question is almost exactly like the last one, but I'll just read it out. What are the panel's experiences of restorative justice in a family violence context? What do you know about what the experience has been for victims of violence? So I'm just wondering, have these restorative justice processes, have they been successful for survivors?
Can I just say the largest program which was cited by the Royal Commission was the large trial in Canada,
yep.
which again, if you go back and look at it, it was path-breaking, and the two academic researchers associated with Joan Pennell and Gail Burford, but the Aboriginal activists involved in those programs, particularly in Labrador and Newfoundland, worked with community groups intensely. So they were programs not imposed on people or where professionals were doing things for others, but we addressed issues in a holistic way, as Auntie Lois is talking about. So that's probably the largest properly evaluated project, and it's sort of sat there in terms of research and for many years and not fully been understood how impactful that those programs were. But now I think we're catching up with that sort of work.
I just say that in the Regional Aboriginal Justice Advisory Committee that I chair, we're looking to have the process formally put into the system for particularly, in the youth detention centres and that. So, and I can only talk about my own experience with using that process, which, as I've indicated, has been very successful. I would like to see it rolled out more broadly. And I think that there is a real opportunity at the very moment to start using that system within the broader justice system.
Nick, a final word?
Yeah, look, I think certainly it is an area that maybe restorative justice or mediation could certainly improve on. I know the first formal victim offender mediation program that was run in the East Kimberley a number of years ago was open to any offences except domestic violence type offences. When I heard we were getting a specific mediator, full-time mediator in the region, was quite an exciting prospect, and then met the particular person who then explained that it wouldn't apply, or they wouldn't apply it to domestic violence. And I guess there's always that reluctance to look into it because of the kind of that fear of, that power imbalance between in a relationship and not wanting to perhaps make the wrong decision. So, but I think there are certainly, opportunities to work more in that space where people want to. I guess it's all about assessing someone's capacity in the same way you would assess someone's capacity in a family law mediation setting. Certainly there'll be cases where it's not appropriate for victim and offender to be together. Having said that, I think looking at extended family and people affected, particularly in Aboriginal communities, that can mean a lot of people. I think there always is that capacity. It's a matter of just adapting to the situation, I suppose.
Yeah, and can I just add, most of where programs have worked, and exactly as you say, we're not here talking about sitting down two people here with a mediator, obviously. That we're talking about expanding the circle of support, including professionals, and in cases where you're changing fundamental patterns of violence, this is over an extended period. So if you start with the do no further harm, we've got to have the right type of process, and it'll be more than one.
It may also, perhaps just the other thing, be a matter of changing the language and how we talk about it. I had an interesting conversation in Kalkarinji recently with a man that was trying to set up a men's program, a men's domestic violence program, and he was calling it Back to Country. And I asked him why, and he said because that word domestic violence, while it might have its dictionary meaning, so to speak, the men in that community just seen it as a finger being pointed, and it was really what those words meant to them was pointing the finger at the man, and I guess there is that discussion of the non-narrative, I think they call it, not providing offenders with an opportunity to explain their behaviour. So I guess it's a different way of approaching it, but that was his particular way. That was a man from the community saying, well, I'm just going to call it something else, but, that was his way of getting people involved. So.
I'm afraid that's all we have time for. Thank you very much to all three of you for a fantastic conversation. Nick, Espie, Auntie Lois and David Moore, thank you very much for a terrific conversation.
Thanks, Damien.